If you have filed any immigration paperwork in the last few years, or if you are planning to file anything in the coming days or weeks, then what I am about to share with you in the next few minutes could genuinely protect you from a serious and costly mistake. Because right now, as of this week, the rules have changed. USCIS has implemented a brand new fee schedule, and the consequences of filing with outdated fee amounts are immediate. They are harsh, and they are happening to real applicants across the country as we speak. I want to make sure that you are not one of them. So stay with me, because by the time this video is done, you are going to know exactly what changed, exactly how much you will now pay, and exactly what steps you need to take today to protect your case, your timeline, and your future in this country. My name is James. I am a senior immigration analyst and consultant with over 6 years of experience tracking, analyzing, and explaining the policies that shape the lives of immigrants and their families across the United States. On this channel, Immigration News Today, my mission is simple. I take the complex, the confusing, and the constantly changing world of U.S. immigration law, and I break it down into clear, honest, fact-based information that you can actually use. Before we go any further, I want to be transparent with you about something important. I am not your attorney. Nothing in this video constitutes legal advice for your specific situation. Immigration law is deeply personal and highly case-specific, and you should always consult a licensed immigration attorney or accredited representative for guidance tailored to your individual circumstances. What I am here to do is give you the information, the context, and the tools you need to ask the right questions and make informed decisions. With that said, let us get into it. As of February 1st, 2026, the United States Citizenship and Immigration Services, which is USCIS, has officially implemented a comprehensive new fee schedule. This change was authorized and finalized by the Department of Homeland Security, which oversees USCIS, and it represents one of the most significant restructurings of immigration application fees in recent years. Now, fee changes are not unusual. USCIS has adjusted its fee schedule multiple times over the past 2 decades. But the scale of this particular update, combined with the immediacy of its enforcement, makes it critically important for anyone who is actively navigating the immigration process right now. The agency has been very clear in its official guidance. Any application or petition postmarked on or after February 1st, 2026 must include the new, updated fee amounts. There is no grace period. There is no transitional window where old fees are accepted alongside new ones. If you send in an application this week with last year's fee amount, USCIS will reject it and return the entire package to you. Not hold it. Not request a supplemental payment. Return it entirely. And that distinction matters enormously, because in immigration, timing is everything. Let me explain why a rejection is so much more than just an inconvenience. In many immigration categories, your place in line, what we call your priority date, is established by the date your petition or application is received and accepted by USCIS. When an application is returned due to an incorrect fee, that original receipt date is lost. You must refile, and your new priority date becomes the date of your corrected submission. In categories where demand significantly exceeds the number of available visas, particularly in the family preference and employment-based preference categories, priority dates can be backlogged by years, sometimes by a full decade or more. Losing your original priority date due to a fee error is not a minor setback. It can fundamentally alter the trajectory of your immigration case and delay the most important milestones of your life by years. That is the true weight of what we are talking about today. So let us walk through exactly what the new fees look like and who is affected. I want to give you the specific numbers clearly and directly, because clarity is what protects you here. Let us start with one of the most commonly filed forms in the entire immigration system, the Form I-485, which is the application to register permanent residence, more commonly known as the Adjustment of Status application. This is the form filed by individuals who are already in the United States and who are eligible to apply for their green card without leaving the country. Under the old fee schedule, the total cost for filing an I-485 was $1,225, and that did not include the biometric services fee of $85, which was billed separately after your initial filing. Under the new fee schedule effective February 1, 2026, the total fee for Form I-485 is now $1,440. Importantly, the biometric services fee has been bundled directly into this new total, so while the number appears to be a larger jump at first glance, part of what you are seeing is the consolidation of what was previously a two-step payment into a single upfront amount. That said, the net cost to applicants has still increased meaningfully, and anyone filing this week needs to ensure their payment reflects the new total. Moving on to Form I-130, which is the petition for alien relative. This is the foundational petition filed by U.S. citizens or lawful permanent residents who want to sponsor a family member for immigration to the United States. It is the first step in the family-based immigration process for millions of people, and the fee structure for this form has now changed in a notable way. Under the updated schedule, the filing fee for the I-130 depends on how you choose to submit your application. If you file online through the USCIS online filing portal, the fee is $625. If you choose to file a paper application by mail, the fee is $675. That $50 difference is not accidental. USCIS is deliberately incentivizing applicants to move toward digital filing, which reduces administrative processing costs on the agency's end and creates a cleaner, more trackable submission record for the applicant as well. If you are planning to file an I-130 and you have the option to do so online, the guidance is straightforward. The online route is both more affordable and creates an immediate digital timestamp of your submission, which can be valuable documentation for your records. Now let us talk about the path to citizenship. Form N-400, the application for naturalization, is the form filed by eligible lawful permanent residents who wish to become United States citizens. Under the new fee schedule, the N-400 fee has been standardized at $710 for online filers. The Department of Homeland Security has publicly stated that the decision to keep the naturalization fee from escalating as sharply as some other categories was intentional. The agency wants to encourage eligible residents to pursue citizenship, and setting the fee at a level that is meaningful but not prohibitive reflects that policy goal. If you or a family member are eligible for naturalization and have been putting it off, this is a good moment to revisit that decision. The fee is now locked in, and the process of becoming a citizen carries with it rights and protections that permanent residency simply does not offer. Now I want to talk about a change that is sending significant ripples through the employer community, the technology sector, and the world of employment-based immigration more broadly. The H-1B visa registration fee has increased dramatically under the new schedule. The H-1B program allows U.S. employers to sponsor foreign nationals in specialty occupations, and the process begins with an electronic registration during a designated registration window, after which a lottery is conducted if registrations exceed available visa numbers. Previously, the fee for each H-1B registration was $10 per beneficiary. Under the new fee schedule, that registration fee has increased to $215 per beneficiary. For large corporations that register hundreds of workers each cycle, this represents a substantial new cost. For smaller businesses, startups, and nonprofits operating on tighter margins, this increase has very real implications for hiring decisions and workforce planning. If you are an employer who sponsors H-1B workers, or if you are a foreign national professional who relies on an employer to sponsor your H-1B petition, this is a number that you and your HR team or immigration attorney need to account for immediately as the upcoming registration season approaches. Let us pause here for a moment, because there is something else in this fee update that I want to make sure you do not overlook, and it is the kind of detail that often gets lost in the conversation about higher costs. The new fee schedule also includes expanded eligibility for fee waivers. USCIS has broadened the criteria under which certain applicants can request a full or partial waiver of filing fees. Historically, fee waivers have been available to applicants who can demonstrate an inability to pay based on household income relative to the federal poverty guidelines. Under the updated rules, the categories of humanitarian applicants who may be eligible for fee consideration have been expanded, including certain individuals with asylum-related petitions and applicants under the Violence Against Women Act, commonly referred to as VAWA. If you are in a financially difficult situation, or if you fall into one of these humanitarian categories, I strongly encourage you to speak with an immigration attorney about whether a fee waiver application is appropriate in your case. The USCIS website, uscis.gov, has official guidance on fee waiver eligibility and the process for requesting one. Do not assume you are ineligible before you check. I also want to address something that USCIS has said publicly about what this revenue is intended to accomplish, because I think it deserves both acknowledgement and honest context. The agency has stated that the increased fees will be directed toward hiring additional adjudications officers, expanding staffing capacity, and working to reduce the enormous backlogs that have built up across multiple application categories, particularly in the I-130 and I-485 pipelines, where processing times have stretched well beyond what anyone would consider reasonable. That is the promise on the table. And I want to be direct with you about how to receive that promise. Fee increases tied to processing improvement commitments are not new in the history of USCIS. The agency has made similar statements in the past during previous fee restructuring cycles, and backlogs have continued to grow in the years that followed. That does not mean this time will be the same outcome. Changes in staffing, technology, and agency priorities can shift processing realities over time. But it does mean that you should plan your immigration strategy based on current, documented processing times, not on projected improvements that have not yet materialized. Check the USCIS website regularly for updated processing time estimates for your specific form and field office, and plan your timeline accordingly. Let me share a realistic scenario with you that illustrates why all of this matters so much on a human level. Imagine a woman, a lawful permanent resident, who has been waiting patiently for the right moment to help her adult son immigrate to the United States through the family preference system. She filed an I-130 petition for him several years ago and has been watching the visa bulletin every single month, waiting for his priority date to become current. That moment is finally approaching. His priority date is close to the cutoff date listed in the current visa bulletin, and she is ready to submit his I-485 adjustment of status application, along with all of the required supporting documents. She printed her filing checklist months ago from the USCIS website. She followed every instruction carefully. She wrote the check for $1,225, the amount she saw on the old checklist, sealed the envelope, and mailed it on February 5, 2026. 3 weeks later, the package arrives back at her door. Rejected, returned. The reason listed is incorrect filing fee. She must now refile. The corrected application goes out with a check for $1,440. But the new filing date is weeks later than the original. And because the visa bulletin moves each month, her son's priority date may now be behind the cutoff again. Years of waiting, extended further, because of a fee discrepancy she had no way of knowing about unless she had checked the official USCIS fee schedule before mailing. That scenario is not exaggerated. It is playing out for real families right now, and that is exactly why I made this video today. So let us talk about what you should do, practically and concretely, starting right now. The first thing you should do before filing anything with USCIS is go directly to uscis.gov and navigate to the official fee schedule page. This is the only source you should trust for current fee amounts. Do not rely on printed checklists from previous filings. Do not rely on information from a friend who filed a few months ago. Do not rely on third-party websites, even well-intentioned ones. Fee schedules change, and the official USCIS website is always the authoritative source. Second, If you have the option to file online, take it. Online filing through the USCIS portal is now cheaper for the I-130, and it creates an immediate digital record of your submission with a time-stamped receipt. Third, if you are in a financial hardship situation or you belong to a humanitarian category that may qualify for a fee waiver, do not let cost be the reason you delay your case. Check the fee waiver guidance on uscis.gov and consult an immigration attorney about your eligibility. Fourth, if you are an employer with H-1B workers or a professional relying on an H-1B sponsorship, connect with your HR team and immigration counsel immediately to ensure that the new registration fee has been factored into your planning for the upcoming lottery season. Fifth, keep monitoring the visa bulletin on a monthly basis. Fee errors that cause refiling delays can push your priority date behind the monthly cutoff, and staying current with the bulletin helps you understand exactly where you stand and what to expect. As of February 19, 2026, all of the fee amounts and policy details I have shared in this video are consistent with official USCIS guidance and Department of Homeland Security announcements. I want to be clear, as I always am on this channel, that immigration policy can and does change. Regulatory updates, court decisions, and shifts in agency priorities can alter the landscape quickly, and sometimes with very little public notice. It is always your responsibility, and I say this with genuine care, to verify the current state of any policy before you take action in your own immigration case. Use the official USCIS website, consult with a qualified immigration attorney or accredited representative, and if something you read online, including on this channel, seems to conflict with what you are seeing on an official government source, always defer to the official source. I also want to take a moment to acknowledge something that is easy to lose sight of when we are talking about numbers and forms and deadlines. Behind every one of these applications is a person or a family with hopes, with sacrifices, with a vision for their future in this country. The complexity of the immigration system can feel overwhelming, and the stakes of getting something wrong can feel crushing. You are not alone in that feeling. And that is exactly why channels like this one exist. My goal is always to make sure that you have the information you need to navigate this process with confidence, clarity, and dignity. If this video helped you understand something that felt confusing, or if it helped you catch something important before you filed, please share it with someone else who might need it. An immigrant family member, a colleague, a neighbor who is going through this process. You sharing this video could save someone months of delay and years of heartache. And if you are not yet subscribed to Immigration News Today, this is the moment to do it. Hit that subscribe button and turn on your notifications, because immigration policy is moving fast right now, and the updates we cover on this channel are the kind that directly affect what you can do, when you can do it, and how you need to do it. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential.